we list, I guess you really just kind of did there, hypothetically, to what criminal exposure might a private foundation be subjecting itself if one of its grantees, is it the blocking the streets sort of stuff, or are they federal laws, sedition? Like what's on the list of things that I could be charged with if I'm a private foundation that's supported groups? We'll get to knowledge in a minute and predication, but about which statutes or city ordinances or something should I be worried? What's my criminal exposure? If I gave money to
Well,
a group that ended up, I guess I would say I'm now even assuming the defensive position of the fund, that ended up having violence occur at its event.
look, I think if a foundation simply gave money to a group that subsequently happened to be involved in some sort of criminal activity, that those bare facts alone would never support criminal liability. I mean, that's just not the way that it works. Generally, there has to be a greater intent that is involved, and so at a minimum, that's going to be knowledge. And then when you're talking about the federal government, not everything, of course, is a federal crime. And so there has to be some nexus to something that's a federal crime. And then, particularly for charities and foundations, you've got this overlay of federal tax law. And so there's this interesting interaction where if their grantees are undertaking unlawful activities, the fact that a foundation or a charity knew about that, that might support, and I may be going out on a limb here, but it might support some sort of tax fraud charge or something like that, because it would, arguably that could be an improper use of charitable assets, and it might well lead to an improper reporting of the use of charitable assets. In other words, they're being put to a use that has to be reported in a particular way, and obviously that's not how it was done. But but for somebody who merely gives money to a group that they support because they support its aims, they support the work that it's doing, and say an employee from that group that goes and does something that's bad, that's never going to be a basis for any sort of criminal liability. I mean, what we're really talking about here, I think, is going to be intentional conduct that was either everybody knew that this was being used for unlawful activity, or they were deliberately indifferent to that fact. They're sticking their head in the sand so they can have plausible deniability about what everybody knew was going on. So, I mean, that's the one nice thing here, and it's a little bit weird to say, but it is a nice thing about criminal liability is that the standards are relatively clear. And ultimately, proving this kind of case is going to put a pretty significant burden on the government. And so I don't think you're going to see many cases that involve marginal conduct, or at least you're not going to see many cases if they bring them on a criterion of cases that they can win that would involve marginal conduct.
In fact, it would not be in this hypothetical consistent with the description of this as an attack on civil society. It's quite a narrow uh, set of facts that would be necessary for a criminal conviction, isn't it? I
I,
guess short of complicity, but it's been narrower than this attack on civil society about which we're hearing from.
I think I think that's entirely right. And look, I mean, this is where it gets political, is going to be the spin on this, right? Because for groups that find themselves, now facing potential risk over funding decisions they've made that were probably indefensible at the time. I mean, of course, their response is going to be, "This is an attack on civil society." Whereas for groups that have been carrying out their missions and paying attention to their obligations under law and not doing things that are potentially subject to criminal liability, which is the vast swath of civil society. This is not really going to be part of their risk profile. I think there are other things beyond what's going on at the federal level that do add to their risk. And my fear is that the way this is being spun as an attack on civil society is going to cause somewhat of a backlash. In other words, we're going to see more activity at the state level that really does fit that definition. Because if some of the state level enforcers view it that way, that the Trump administration is undertaking an attack on civil society, their response may well be, well, we're going to get into this game too, except we're going to do it from our political side. So they're going to take something that is not really all that political in terms of the mechanisms by which it's being carried out, and potentially flip the script on that and make it a more political set of action, set of activities. So
Mhm.
that could be a perverse result of this.
No, I worked at a foundation. I was on the program staff. We were fretful about a lot of things, including being called by the IRS. I must say we were not worried about criminal, but yeah, okay. The grant contracts have language saying the recipient's not going to break the law. Am I covered? Are we okay? Is that enough?
I mean, I think, it's not enough to just throw language into a contract that says that, although that certainly helps. I mean, what the key questions to ask are going to be, what do you know? What's reasonable diligence? Um, I mean, it's the kind of thing that any responsible foundation would be doing anyway. I mean, if you're working at, a foundation that forget taking compliance seriously, one that takes its mission seriously. Um, the people working on grants are going to know what the grant recipients are doing. They're going to be following, they're going to know the people who are involved. They're going to be following their activities. And this is never really going to be a risk. Um, and so, for this to even be a prospect, and of risk to a donor organization, there has to be at a minimum some form of knowledge. And like I said, if you're responsible, that's never really going to be a problem.
And when you say knowledge, does that include should have known, should have predicted? Anybody would have figured out that X would have occurred if money was given to Y on date B, I guess I'm saying what's knowledge? Does knowledge include predictability?
It can, right? And it can for the reason that at the end of the day, knowledge is a fact question, right? And it's something that's got to be proved or disproven. And when it's being proved, when the government is trying to prove it, these are the kinds of tools that it can use. In other words, you know, you read CNN every day or you watch CNN every day, and this was on CNN. Probably you saw it. Other people in your organization knew this. Things of that, you get a newsletter, you receive a newsletter in your inbox, and the newsletter had an article on it. That said, I don't see there being a lot of risk here in exactly that vein. I mean, it's one thing to say, somebody was sticking their head in the sand. They were deliberately indifferent. And that's the kind of thing that is just irresponsible that you can't really get away with. I mean, you can't deliberately blind yourself to unlawful activity, turn a blind eye to it, and then just say, well, we didn't know about it. But it's another thing to carry out your normal diligence and to simply be unaware. I mean, if you are a responsible organization and you're carrying out your normal diligence, at the end of the day, that's going to be for this category of risk, I think, a reasonable compliance strategy.
Is there a set, and I want you to know I'm cognizant of your time here, so give me a couple more minutes. It'd be possible, and not even like really too theoretically, this is plausibly possible for a private foundation, which is, I guess, what I'm more asking about here than the nonprofit, to be non-complicit or to be okay with the criminal application, but at risk in the tax one. Could I be criminally non-complicit or non-culpable, but risk losing my exemption or exempt status? Uh, or have something be considered a taxable event, I guess, even short of that a little bit. But there's cross-cutting considerations here, right? And naturally, one would be in the hypothetical I'm saying more worried about the criminal. But how much lower is the second worry of the jeopardization of status compared to that?
Well, I think in general, that's probably going to be based on different sorts of activities. I think the risk is there. I mean, at the end of the day, if what you're talking about is political targeting of civil society organizations, political targeting of private foundations and charities and so forth, really everything is on the table. It's one thing to talk about supportive groups that are involved in illegal activities, but then if a group is being targeted, because of the political act, because of their advocacy, because of the area, because of their point of view, because of what it is that they're trying to do, potentially that law enforcer is going to bring to bear every aspect of the law that he or she is responsible for enforcing. And we've seen this so much at the state level, right? If you look at some of the most controversial cases, enforcement actions that have been brought against nonprofit organizations in recent years, they've all been based on meat and potatoes compliance issues, accounting controls, private inurement, um, proper tax records, just the things that everybody ought to be getting right, but unfortunately, a lot of groups just let slide because they just don't have a focus on just ordinary compliance activities and proper auditing and making sure that they've got their books in order. So, I mean, that's always my advice for every group that fears that they might be targeted based on their activities. In other words, that they might suffer political retaliation, which is make sure your house is in order, because at the end of the day, it's very unlikely that a law enforcement agency is going to come after you, technically speaking, based on your advocacy or based on your viewpoint. In other words, that's not what they're going to say. They're going to come after you because somebody had their hand in the cookie jar. You didn't have adequate controls. You had conflicts of interest that weren't taken care of appropriately. You didn't follow your internal policies and procedures. Those are the things that at the end of the day can take a political risk and turn it into an actual enforcement risk.
Two more, Andrew, as the clock ticks. The revocation process. Can you just describe that? And how would that work? How long would that take? Who fills out what form? And what is the revocation process like? How does that work or not work, as it were? Who was last revoked and how long did that take?
I have no idea. I am not the tax exempt guru. That's my colleague, Alex Reed,
Got
and
it.
he could talk your ear off about that. What I will say is, we've seen, attempts at the analog of that under state law, because of course, nonprofits are generally either trusts or corporations. They're always created under state law. And so they're governed by state law, typically by the attorney general of the home state acting in a parent's patriot capacity.
Yeah.
And so, yes, we have seen in recent years states' attorneys general trying to dissolve
Yep.
Charitable corporations and charitable trusts, or seize their assets, or things of that nature. In the past, that was really just confined to outright frauds. The veterans charity, where really the money was being used on Caribbean vacations for the founders and things like that,
Mhm.
as opposed to giving the money to charitable purposes. It's been a very recent development that we've seen that now being pressed against what I think people would say are legitimate organizations, albeit arguably, or at least claimedly, ones that maybe had some internal control issues, but were not in and of themselves. They weren't frauds. They just maybe had some management issues. So
Mhm.
that's something new, and the process there is very laborious. I mean, that does require going to court, and so far those have been very serious battles. But I mean, think about it. It's long drawn out, bet the company type litigation, and it's proven to be very, very burdensome and expensive and distracting. So of course, that's something that any organization would want to avoid.
Yeah. Every type of like executive branch investigation we've been hypothetically contemplating here could also be done by Congress, right? Or a congressional committee. And might that start to occur with changes in policy governing the sector?
Well, so congressional committee investigations, it really does differ based on the committee, based on what their jurisdictions are, and based on the rules they have governing, how it is that their investigations are carried out. How do they issue subpoenas? Does it need to be voted on by the full committee? So there are a range of requests and demands that an organization can receive from Congress, and the most frequent ones that groups get are just single member letters, accusing a group of some kind of awful thing, usually having the wrong policy view or something like that, and then demanding a whole swath of information, sometimes including donor information and internal communications and so forth. And in general, an individual member doesn't have any power to do anything whatsoever. I mean, a letter from an individual member is really, it's a piece of paper, unless they email it to you, in which case it might not even be that. And one mistake that I've seen is that very frequently an organization will receive a letter like that, or sometimes they'll receive one from a committee chair, or even sometimes as part of some type of investigation or something, and they panic. They think that this is the same as a subpoena, that they face some immediate legal jeopardy. One thing to recognize about the process in Congress is that it moves very slowly. You can think about how you want to respond. If you want to push back, there are opportunities to push back, which is worth doing if a request is illegitimate or abusive. You should never give in when that's going to compromise, your speech rights, your associational rights, rights to donor privacy. Congress has no right to invade those things, and certainly individual members don't. But even when there is a legitimate basis for a request and there's some prospect of enforcement, there are so many steps down the road and opportunities for negotiation that it's never something really to panic about. It's something that can be dealt with in an orderly and thoughtful fashion. Ideally by somebody who has some experience in the area and can understand the back and forth process that, when it's done properly, this always involves.
Can I cheat and get one more in, Andrew? Is there too much defensiveness on the part of those who speak for civil society or philanthropy? I mean, it doesn't it, might there be some benefit in an acknowledgement that, okay, somewhere under certain circumstances, there might be something worth looking into. Uh, wouldn't that increase trust more than the totally defensive position of get out of our you're attacking civil society, you're going after Tocqueville, wouldn't that increase trust in the sector
Unfortunately,
more?
I'm going to give you a very lawyerly answer,
Okay.
which is that I don't think that there is too much fear and concern in this area, but I think that it's very misplaced. Um, Especially recently, there's been so many fearful articles, so many people who are raising concerns about enforcement activities that are likely to affect very few organizations that do not appear to be broadly targeted and that appear to be, it's still early days and so we'll see, but appear to be aimed at activity that, if they're going to do what they say they're going to do, is activity that everybody should have understood was problematic from day one. And so I think in that respect, a lot of the concern has been misplaced. At the same time, we are seeing increasing attacks on organizations that are doing vital civil society work. We're seeing that at the state level. We've seen it at the federal level, and it does exert a toll. It chills speech. Unfortunately, it makes the resources of civil society less effective because they have to spend money on compliance and attorneys. Um, and at the end of the day, it turns things that ought to be vibrant into more defensive arenas, and just makes everybody a little bit more fearful and tiptoeing around. And so it is a hindrance on civil society, I think, in a way that is bad for our society as a whole. And I don't think that we've really done enough to talk about that. Some people have been outspoken about that, but I think too frequently there are these attacks, particularly at the state level, and many people have said, "Well, that's not me. It's not my political ally, and so it's not something that I care about." And so, if there is any upshot to the current wave of panic over the Trump administration's activities, it's that maybe it will help, broaden attention to what I think is this more important underlying issue that is, as I said, really just been slowly developing over a period of years.
Yeah. Anything I did not ask, Andrew, that you would want to answer anyway?
No, I don't think so. This is very comprehensive.
Great. Then let me just thank you for taking the time to talk with us, Andrew Grossman of Baker Hostetler. Thanks so much.
Thank you.